Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. I am old enough to have lived through Watergate, and living through Watergate was quite the interesting experience. And one of the really interesting stories that came out of the whole Watergate debacle for President Nixon was the story of how Rosemary Woods, his private secretary, managed to delete 18 and a half minutes of audio tape. And I really don't think anybody ever believed the story, but it basically required you to believe that she was reaching across while keeping her foot on the dictaphone pedal while she went to answer the phone. And it reminded me of the game of Twister. And so whenever I think about Watergate, one of the first things that I think about is this sort of Twister event where Rosemary Woods said, oh, geez, I somehow managed to delete 18 and a half minutes of tape, stretched out like this. It doesn't make much sense now any more than it made sense at the time. You develop a little bit of I would say, a jaded view of politics as a result of the people who practice it. And even if it wasn't necessarily believable, there were people who gave it some credit, which just amazes me. So today we're going to talk about a case from Connecticut. It's called State of Connecticut versus Anthony V. In Connecticut, they don't put your name on a criminal case if it's possible that one of the victims could be identified by knowing who you are, which is a really interesting way of looking at privacy, but also really frustrating if you want to find out facts related to something like a case, in this case, involving a Pieta revolver and an accidental discharge that wound up killing a woman. Now, normally, if you put those three things together, you're not in Connecticut, you're in New Mexico. But in this case, we're in Connecticut, and there is one difference. This Pieta revolver is actually a black powder weapon, because I strongly suspect that he could not lawfully own a firearm that uses cartridges. Maybe because he has prior convictions that's not really spelled out in the record. A long time ago, there was an audio version of Bill Cosby telling a story about how children manage to spin lies, and they will say things like, well, you know how you told me not to run? Well, I wasn't really running. I mean, my feet were moving fast, but I wasn't really running. And it always amazes me when you read a criminal case, it sounds to me like they all listen to Bill Cosby, because some of these stories are just pretty hard to give credit to. But in spite of that, the Connecticut Court of Appeals did indeed give credit to what, frankly, is kind of a shaggy dog story here. So here is what you have. You have two people, a man and a woman, who it is reasonable to infer have a history of growling at one another, and I think sometimes doing more than that. But that wasn't actually spelled out in the opinion, which we'll get to in a minute. So what he tells, the story that he tells, is that periodically he has this .44 caliber instrument in his on his bedside table, and periodically he likes to dust it off and make sure there's no oil or anything like that on it. And he goes and picks it up to carry it into the bathroom to get a napkin to wipe off some of the grease, I guess. And in the process, he trips. And when he trips, he pushes the gun out in front of him, and it goes behind his girlfriend's left ear. He actually pulled the trigger, and as a result, the young lady was unalived. And he was charged with manslaughter. And he was convicted of manslaughter, but the Court of Appeals in Connecticut has reversed that guilty verdict, and they're sending it back. Let's look at a little bit of this case and see if we can make heads or tails out of it. So Anthony V. appeals from a judgment of conviction manslaughter in the first degree with a firearm. He raises two claims of error. The first claim is that the evidence is insufficient to support his conviction, something that they disagree with. And two, that the court's failure to instruct the jury on general intent constituted plain error. Now, normally, when you have an error that is made during trial, your lawyer has to either object before the error occurs. If somebody says, we're going to admit this testimony, and you object to it, you object and you preserve any error that comes from the admission of that. Or once somebody testifies in a way that's not expected and that violates some evidentiary rule, you raise the objection, you make that objection plain. If it's overruled, you have preserved the error. In this case, and in the case of jury instructions, one of the things that you have to do if you don't think jury instructions are full or complete or give the jury the right information to decide the case is you have to submit an alternative instruction. You have to say, no, it wasn't Colonel Pepper in the library with a hammer. It was, Mr. Mustard in the den with a poker. Whatever it is that you believe supports your version of events, you have to put it into the form of a jury instruction, and you have to make sure that you give all of the instructions that are necessary to give the client a fair trial. If you don't do that, the error is not preserved. And if the error is not preserved, then it becomes an issue for plain error review, which is the most difficult way to get any error overturned in a trial. Because plain error is very, very unusual, because judges are usually better than the lawyers at what's going on in a trial, and usually will spot plain error and will simply sua sponte say, well, I think we need an instruction here on general intent, which is what the issue is in this particular case. So as you can see, the court runs through the issues here. Before midnight on October 17th, 2020, they got a call saying that there'd been an accident, and in this room they found the defendant performing CPR on the victim who had planned to marry him. And there was a gunshot wound to her head. The defendant consents to 3 police interviews. In his interview statements, the defendant consistently maintained that the victim's death was the result of a tragic accident. More specifically, the defendant stated that just before bedtime, the victim was using the toilet in the bathroom adjacent to the couple's bedroom, with the door open, when the defendant decided to wipe down the loaded revolver that he kept in a box in the bedroom and cleaned off periodically to remove any accumulated dust and oil. Aware that there were napkins in the bathroom that he could do that with, because the couple had run out of toilet paper, the defendant, loaded revolver in hand, walked toward the bathroom to retrieve a napkin. While approaching the bathroom, his eyes focused on the revolver, which he was trying unsuccessfully to render safe. He started to enter the bathroom. He tripped on the door jamb, fell forward toward the victim, who was seated on the toilet only a few feet away, and although still in possession of the revolver as he fell, the defendant couldn't control it. The barrel of the gun inadvertently struck the side of the victim's head, and the gun accidentally discharged. So, you'll pardon me if that sounds a lot like sort of a twister narrative. It would be pretty hard to reconstruct that or reenact that. But that's what he told the police. So his first claim was that the evidence was just completely insufficient to support a conviction for this. And the court doesn't agree. According to the prosecutor, the defendant's conduct in placing the revolver was likely the result of another one of the alcohol and drug-fueled arguments between the defendant and victim. At the conclusion of the trial, the jury found the defendant guilty of manslaughter in the first degree with a firearm. The defendant claims the state failed to prove beyond a reasonable doubt that he was guilty. The defendant contends instead that the evidence demonstrates the cause of the gun coming up against the defendant's head was not a volitional act, but rather a tragic, calamitous accident. We are not persuaded, they say. So basically what they're saying here is, okay, I understand this is your story, but we're not buying it, at least not this part of it. They say, we conclude that this evidence and the inferences that the jury reasonably could have drawn therefrom were sufficient to support the state's theory that the defendant intentionally placed the muzzle of the revolver to the victim's head. And they note, look, we understand what you're saying is that there's an alternative explanation here, but we do not find the defendant's argument so compelling as to require the conclusion that the jury rationally could not have found as it did. And as I said, it's always a pretty difficult burden trying to overturn a jury verdict. And they say, we therefore conclude that the jury was not obligated to accept the defendant's version of facts and reject the factual scenario advanced by the state. Then we move into part 2 of the opinion, which is really interesting. The defendant also contends that the court improperly failed to instruct the jury on an essential element of the offense of manslaughter, namely that the defendant acted with general intent, that is, volitionally, in allegedly placing the muzzle of the revolver against the victim's head. Because the defendant did not raise this claim in the trial court, he seeks to prevail under the plain error doctrine. We agree with the defendant's plain error claim and accordingly conclude that he is entitled to a new trial. Plain error is a doctrine that a court invokes to rectify a trial court ruling that, although either not properly preserved or never raised at all in trial, nonetheless requires reversal of the trial court's judgment for reasons of policy. In addition, the plain error doctrine is reserved for truly extraordinary situations in which the existence of the error is so obvious that it affects the fairness and integrity of the public's confidence in judicial proceedings. Plain error is a doctrine that should be invoked sparingly. Implicit in this very demanding standard is the notion that invocation of the plain error doctrine is reserved for occasions requiring the reversal of the judgment under review. So it's a very seldom used approach to getting a reversal in a criminal case. Let's discuss for a moment the issue of general intent versus specific intent. There are two kinds of mens rea, or essentially a guilty mind. And the two kinds are general intent, which is the intent to commit the act, the physical act. In other words, the striking of the blow with a fist or kicking somebody with your foot. Those are two physical acts that could constitute the crime, for example, of assault, the general intent. I intended to strike them, right? And then there are specific intent crimes like I intended to unalive this person. My aim, or the person's aim, was to deliver a fatal blow. And in those situations, you not only have to prove the physical act, right, striking someone, you would have to prove that the intent was there as well, and you can generally do that from circumstantial evidence. And here's how the court phrases it. Such an intent to perform certain acts prescribed by a statute we have referred to as the general intent ordinarily required for crimes of commission rather than omission. And they go down to say, as also noted previously, the requirement of general intent is satisfied by proof that the defendant's act or movement was deliberate, conscious, or purposeful, and not merely an accident or mistake. In other words, the state needed to prove that the defendant intended to make the bodily movement that constitutes the act the crime requires, in this case, putting it up against her head. In the present case, therefore, the state was required to prove that the defendant acted volitionally to use the revolver in the commission of the offense by intentionally placing it against her head. So I'm going to cut about 10 pages out of this opinion here and just narrate for you what the real issue is here. The judge needed to draft and give an instruction to the jury to the effect that the state had the burden of proving that it was a volitional act and not an accident. In other words, the state had to disprove the accident theory. There was no instruction requested. There was no instruction given. It was up to the defense attorney to ask for that instruction. He didn't ask for that instruction, so it wasn't given. As a result, that's why they had to ask for plain error review. And here the court agrees. Look, it's an element of the offense, general intent. And if the instructions do not fairly capture that requirement, and the court decided that they did not, then we have to reverse this verdict because the jury wasn't properly instructed. And that's what it comes down to. It comes down to a failure by the court to give the proper jury instruction, and as a result, get the person a fair trial. It's well established that the defendant is entitled to have the jury correctly and adequately instructed. If justice is to be done, it is of paramount importance the court's instructions be clear, accurate, complete, comprehensible, particularly with respect to the essential elements of the crime. And here they decide that that wasn't the case. These fundamental requirements were not met in the present case because of the omission of a jury instruction on the element of general intent. As a consequence, the defendant was deprived of a fair trial and a reliable verdict. To avoid manifest injustice, a new trial is required. The judgment is reversed and the case is remanded for a new trial. Now, if I had to guess, what's probably going to happen is, because this man was convicted, and because appeals always take time, usually somewhere between 6 to 18 months to get an appeal through, and then maybe even longer to get a decision, he could have been in prison now for 2 years. And what may happen now is, rather than going through the time and expense of a new trial, they may offer him a deal where they basically say, okay, will you accept a conviction for negligent homicide, which is a misdemeanor in Connecticut, unbelievably, a misdemeanor, and as a result, he would probably be released from prison much more quickly than he would be under the manslaughter conviction. Well, that's what I have for you today. Hopefully you found this interesting, a case that involves a rather convoluted set of facts, something that's really kind of hard to believe. The court holds that the state's evidence is sufficient to prove manslaughter, but then it reverses on plain error, which again almost never happens, on this idea that he was entitled to an instruction on his rather convoluted theory of how this all happened. It's really good to see an appellate court like the one in Connecticut working to defend a defendant's rights to a fair trial. Thank you for watching. If you have any questions, drop them in the comments down below or email me at the address above. If you have the opportunity today, go out of your way, do something nice for somebody, and then come on back down here tomorrow, join me at the beach. We'll talk about something else. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.